Thank you, Mr. Speaker. Mr. Speaker, I certainly understand the challenges faced by the member for Castries Southeast in taking responsibility for this bill before the House. I think all of us would have preferred if the minister with the responsibility was here to do so, for the very simple reason that we might have explored his thinking a little more clinically, but that is not to be. Mr. Speaker, the bill before us does not purport to repeal the Constituency Council's Act, and as the minister suggested, it attempts to fill in or deal with some gaps. Of course, the old Corporation Act, the former Castries Corporation Act, number 22 of 1967, was effectively repealed by the Constituency Council's Act. And therefore, when actions were undertaken pursuant to that act, those actions would have been unlawful because the act was not in existence. But the minister says that gaps are being dealt with, and the intention is to fill in some of those gaps. Mr. Speaker, there is obviously this nexus between the Constituency Council's Act and the bill before us. And perhaps it is worth our while to reflect just a little, because the Constituency Council's Act was premised on an underlying philosophy and underlying approach. It is true that the Act fully respected the fact that there was a government in office, government had a majority, and therefore effectively had the majority say in the composition, the membership of the various councils falling under the jurisdiction of the Act. But the Act conceded some degree of partnership, some degree of sharing. So, for example, in the Constitution of the Councils, in Section 5, it says that the members who are appointed to these councils would include among them a nominee from each of the political parties represented in the House of Assembly. Whether, of course, all parliamentarians have made use of that section is unclear, and some may not have for their own reasons. But be that as it may, I just want to draw your attention again to Section 18, which says that any time that members of Parliament receive a notice of a meeting of a council, a member of the House of Assembly who is notified of a meeting may, if he or she wishes, to attend the meeting. Again, this underlying concept of partnership to try to minimize conflict and division as much as possible in the various communities for which the councils have jurisdiction. The Constituency Councils Act go as far as to empower councils to hold biannual public meetings at a time approved by the minister to inform constituents of the progress and agenda of the council. I don't know if any council has made use of this provision in the Act, but the important thing is that where the council decides to hold a meeting for members of the public, the member of the House of Assembly for that particular constituency is also invited to attend such a meeting, to participate in a meeting. Again, this notion of partnership, this notion of openness. I say so, Mr. Speaker, just to make the underlying point before I move to assess the bill, that perhaps it's a little unfortunate that we are approaching this bill ignoring the partnership that the former act attempted to create. I believe that given the fact that we are dealing with the Castries Constituency Council, which of course encompasses constituencies of Castries East, Castries Central, Castries Northeast, and Castries South. I'm correct that the proper thing really, Mr. Speaker, should have been to perhaps allow for discussion between the minister and the reps in those constituencies to reflect on the provisions of this bill. I believe it's a missed opportunity. It's really unfortunate because there are useful aspects of the bill, but equally there are aspects of the bill, I think, that are fraught with problems, both on the technical side and otherwise. Mr. Speaker, I have no expectation of reform of any of those provisions at this stage because of the complexities of the provisions. But I want to start by looking at Clause 5. Clause 5 speaks of the constitution of municipalities. And it's an interesting term to use because I think that was the old term that was used in the 1967 Act. Seems to me that we are stuck in time and place, that we want to reinvent this concept of municipality and invoke it once again. But this is what it says in Clause 5, subsection 3. The Castries Constituency Council shall give 1 month's notice of the intention of the Constituency Boundaries Commission to review the boundaries of the municipality by advertisement in the Gazette and in at least one newspaper of general circulation in the municipality. Now, Mr. Speaker, given the fact that the Constituency Boundaries Commission is established under Section 57 of the Constitutional Institution, and that this is a body that is totally supposed to be independent, how then can the Constituency Council, Castries Constituency Council, be empowered to give notice of the intention of the Constituency Boundaries Commission to review the boundaries of the municipality? How can you do that? I don't understand, and somebody will need to explain to me, how is it that the municipality can tell the Constituency Boundaries Commission that we need to look at the boundaries that straddle the constituencies and proceed to give 1 month's notice. Now, of course, it doesn't say that. But the fact of the matter is that it has to be triggered. Now, to add to the complexity, Mr. Speaker, just imagine if this section is intra vires Section 57 of the Constitution. Just imagine if it is. The Boundaries Commission, and by the way, it has been acting unlawfully and illegally for years, but that's another story. The Boundaries Commission issues authorized boundaries for constituencies. Its mandate is to review boundaries. So, what is the purpose if the Boundaries Commission has demarcated boundaries for electoral purposes? The Castries Constituency Municipality then tells them we want these boundaries reviewed, and then boundaries are produced that are at odds with each other. Just imagine. So I am at a loss to understand why this did not simply say that the boundaries of the municipality of the Castries Constituency Council shall be as determined by the Constituency Boundaries Commission. So I want to find out how this section is intra vires, a body constituted by the Constitution, a body that is supposed to be independent, a body that is supposed to do its work without any direction or influence from anybody or any authority. So, Mr. Speaker, I hope we can get an answer. I am a little mystified by Clause 6, Subclause 5. And we need some explanation why this clause exists in this bill. It says, an act or a decision that is purported to be exercised by the mayor under the Repeal Act or the Castries Constituency Council under the Constituency Councils Act, Chapter 17.19, or by the corporation before the commencement of the date of this act are deemed valid. Why on earth would you put in a clause like this in this bill? For one, the bill is conceded that there is a possibility that the mayor may have used powers under the previous act, which has since been repealed. Because the language is clear. An act or a decision that is purported to be exercised by the mayor under the Repeal Act. And the list of repeal acts are clearly stated in the Constituency Councils Act. And what are these acts for which validation are required? What acts have the mayor committed that require validation? Why is a provision like this appearing in this legislation? What is the mayor being protected from that requires this section? Is there a story here? And what is the story? Why would you move to protect an officer to that extent? Of course, there may be situations sometimes that legal errors are committed. There may be situations, but if you're going to come to Parliament and argue that you're going to correct legal errors, then make another provision. But then someone has to explain to me Clause 7. Functions of the Castries Constituency Council. And we have a list of functions. There are very few issues. But then we have paragraph C. It says, without limiting the generality of subsection 1, the functions of the Castries Constituency Council include, under C, to ensure cleanliness of streets and other public places, nothing wrong with that. The width of streets and other places made or to be made, nothing wrong with that. And the regulation of the erection of houses, buildings, and structures in the municipality. Now, clearly, that trespasses with the Physical Planning Act. If you're going to prescribe the regulation for the erection of houses, buildings, and structures in the municipality, then clearly you are interfering with the Physical Planning Act and the authority of the Development Control Authority. This is not to say, on the other hand, that the Castries Constituency Council ought not to have some responsibility over buildings. But then you have to find the correct legal approach to do so. Surely what could have happened here is that the Castries Constituency Council could consult the Development Control Authority regarding regulations for the erection of houses, buildings, and structures in the municipality, some such approach. But I don't know how this can, in such clear and direct language, interfere with the jurisdiction of the Development Control Authority without, of course, amending the legislation. I am interested in the functions of the mayor, Mr. Speaker. I go to clause 12. The functions of the mayor are, and to supervise and coordinate the affairs of the Castries Constituency Council. To preside, C, to preside over ceremonial functions. D, to sign bylaws and documents, etc. And E, to perform other functions assigned in this act or another enactment. Then, but B, to, through the Chief Executive Officer, control the activities of the employees of the Castries Constituency Council. What do you mean by this? What are the activities of the employees that need to be controlled? And I'm certain that honorable members would believe that this is just a wanton question asked out of mischief, but it is not. Because the council hasn't been involved in litigation for all kinds of reasons. I mean, there's one matter that has had to undergo litigation. Why? Because an employee was said to be rude to the mayor, and an employee was unhappy with parking arrangements made for her. She was sent marching. Up to now, the council has not met the judgment, the decision of the Labour Commissioner in this matter. But what are the activities that you're talking about? It's at large. You're talking about activities where you park, the color of your car, how you dress, what time you come to work, what do you do in your spare time or your breaks? What are you talking about? I don't think that was the intention. I suspect the intention may well have been to refer to those conditions of work or the responsibilities in respect of the employment of the individuals of the council. But whether the mayor should be so involved is a different matter. Mr. Speaker, I don't think anybody would seriously doubt the need for the mayor and deputy mayor to be deemed justices of the peace of the municipality. I don't think so. I mean, there are occasions when documents have to be signed. It's a useful authority. But the question is, what is the duration of these appointments as justices of the peace? Is it only during the period during that they hold office, or does it continue after the period they've left office? We need to clear these simple matters. Otherwise, problems could arise and problems could emerge. I believe, Mr. Speaker, that the bill is sorely lacking in respect of the employees of the corporation and who really is responsible for the employees of the corporation. I referred earlier to the fact that the mayor, through the chief executive officer, is supposed to control the activities of employees of the Castries Constituency Council. And then we see under clause 18.2, the chief executive officer shall manage the day-to-day affairs of the Castries Constituency Council. I suspect we have to read that subject to the earlier clause that I mentioned in respect of the mayor having the authority to control the activities of the employees of the corporation. Now, why would you want to give a mayor? You have elevated this place to a municipality, and I think I have the pronunciation right now, municipality. Why you want a mayor involving in the management of employees, giving instructions as to how employees should be managed, and taking things in his own hands? Why? When you have a chief executive officer, all you need to do is to make your chief executive officer accountable to you. Why you want to dabble in those things? And that is why the council has found itself in so many legal issues before the courts. Because of this dabbling with employees and not following rules and procedures that may be required. Mr. Speaker, maybe if when you look at part 3, it would have been better to describe the authority as a Castries Municipality Council and describe the police as a Castries Municipality Police. To be consistent may be better. But there are some troubling provisions in this. Very, very troubling provisions. And again, this is where I think had there been debate and dialogue between the four representatives and the minister, some of those very troubling provisions could have been dealt with. I don't know, Mr. Speaker. Your job is to preside over meetings of this House. Your job is not to appoint, to prescribe on legality or illegality. I mean, you could only watch, caution sometimes. But look at clause 222.2. The Castries Constituency Council shall, in consultation with the Commissioner of Police, appoint for that purpose a sufficient number of Castries City Police. So what's going to happen? The appointee is really the Castries Constituency Council. So you have a situation where the Castries Constituency Council is consulting the Commissioner of Police on appointment of city police. An effort is made to clothe some of the city police with the powers of the police, but the appointing mechanism places the locus of power in the hands of the Castries Constituency Council. Surely, that cannot be right. That perhaps this should be worded the other way around. To mean the Commissioner of Police shall, after consultation with the Castries Constituency Council, appoint for that purpose a sufficient number of Castries City Police. That has to be the correct thing. How can you proceed to allow the cooperation, the city council, or whatever it is, the constituency council, to appoint individuals after consultation with the police commissioner? Because you don't have to accept the advice coming from the consultation process, as you know. Nothing compels you. You can hear, you can listen, you can disregard. One would have thought that if you are really clothing the city police with police powers, that what you would have done was to allow the appointment to be done at least formally by the Commissioner of Police after consultation with the Constituency Council. And then you go down to clause 25. This is really a troubling piece of legislation. Very troubling. The Commissioner of Police may, on the advice of the Castries Constituency Council, permit persons appointed to be Castries City Police to wear the badges of the ranks and uniforms similar to those worn by members of the respective ranks in the Royal St. Lucia Police Force. So, he has a discretion. He may, on their advice, allow them to wear badges of the ranks and uniforms similar to those worn by members of the respective ranks. So it is very clear that what you're attempting to do is really to clothe these city police officers with the powers and authority of ordinary policemen. But what you are doing is allowing the locus of power essentially to reside in the Castries Constituency Council. Mr. Speaker, I want you to just look at clause 27. Don't forget the intention here is that we are setting up a municipal police, a constituency, a city police. Look at clause 27. A Castries City Police, in addition to the special powers vested in him or her under this Act, has in respect of the whole of St. Lucia the powers, privileges, and immunities conferred on a constable by the common law, and the powers, privileges, immunities, and liabilities conferred or imposed on a constable of corresponding rank by the Police Act. Now, Mr. Speaker, I deliberately adverted to your previous role as a magistrate. And I'm not asking you to make a judgment about this section. That's not your function. That's not your function. But first of all, how can you establish a Castries Constituency Council police force, but at the same time, you are giving him the whole of in respect of the whole of St. Lucia, the powers, privileges, and immunities conferred on a constable by the common law? Now there's another problem which I shall come to, which is the most serious problem. What does that have to do with the whole of St. Lucia? Why should they have any authority in my constituency in Vieux Fort Town? To do what? Why? Why should they enjoy like privileges? But more seriously, Mr. Speaker, it is this reference. Privileges and immunities conferred on a constable by the common law. Now, something has to be clarified there, Mr. Speaker. I really want somebody to explain to me what are the common law principles that apply to police officers in St. Lucia. What are they? As far as I am aware, Mr. Speaker, St. Lucia adopted a criminal code way back sometime in 1916. And we have always had a criminal code to govern our criminal law. So where does the common law come into this? Is there some reception clause somewhere that says that the police have all the powers they have in a criminal code, but also the common law powers, for example, that police in UK have? Where's the source of this? I am curious to find out. Very curious to find out. I will readily admit that when we are dealing with civil matters, where we have imported the common law of England in civil matters, then to that extent, police as they relate to those civil matters may enjoy some of the powers in relation to those civil matters. So somebody will have to re-educate me, Mr. Speaker, and happily I will accept whatever re-education that is provided in that regard. So, Mr. Speaker, come on. Come on, think a while. Think a while, Mr. Speaker, think a while. Just look at arrest and detention, clauses 28 and 29. Look at clauses 28 and 29, Mr. Speaker. One of the most important powers of a police force is the power of arrest and detention. These powers in the past have brought endless litigation. And from time to time, there are issues arising with regard to the exercise of those powers. Now, under clause 28, we notice that if an individual refuses to give his or her name and address to a city police, then that individual could be charged. Of course, equally, if an offense is committed. But listen to this, listen to clause 3. On receipt of a charge sheet under subsection 2, the Castries City Police on duty at the police station shall detain the person at the police station until he or she can be without delay, and in any case not later than 72 hours after the arrest and detention be taken before a magistrate to be dealt with according to law. Now, on the surface of it, generally correct that you have to make sure that within 72 hours you lay your charge. But it says the Castries City Police on duty at the police station. Suppose a person from the Castries City Police who is in the police station happens to be an ordinary city police constable. You are saying that an ordinary city police constable can make a decision as to whether a person shall be charged or not? Surely something has to be wrong, because these are powers that are usually exercised by senior police officers. Unless you're going to have a provision in there which says that the city police on duty has to be someone of senior rank, and that is included, then you need to question this. But what is worse, Mr. Speaker? Look at the power to grant bail, something as sensitive as the power to grant bail, again, that has been the subject of endless litigation. It says, if a person who has been arrested without a warrant by a Castries City Police under Section 38 is brought to a police station and a magistrate is not sitting, the Castries City Police on duty at the police station may, unless he or she has good and sufficient reason to do otherwise, which reason must be recorded in the station diary, admit the person to bail by recognizance without sureties for an amount not exceeding $2,000 to appear before a magistrate at the time and place specified in the recognizance. It seems to me that what we are doing is to grant the city police far more powers than we even grant to our police officers. Normally, the exercise of such a discretion is assigned to a police officer of some rank. I can't recall exactly what the rank is, but in most police stations, it is usually the rank of sergeant. Of course, I may be wrong, but it's extraordinary that a member of the city police would have that kind of authority. Mr. Speaker, I want to urge some caution with respect to clause 31. I really do, Mr. Speaker, because you see, this notion that you can sell property at your whim, albeit in this case that is suggesting after the expiration of 3 months, and I'm referring to clause 31 2b. There is not even the requirement that a notice be put in the newspapers or whatever communication that this property is going to be sold. Not even that basic requirement. Why are we clothing these individuals with these powers? Now, Mr. Speaker, I noticed the elaborate provisions dealing with finance. I would leave them there because I believe that there are powers under the Constituency Council's Act that I think empowers the relevant ministers to take action when they deem fit. But I am concerned about the power to enact bylaws. And it is certainly the case, Mr. Speaker, that in most countries where you have municipalities, that powers are granted to enact bylaws to govern the business of council. And here we have a long list of potential bylaws without limiting the generality of subsection 1. The Castries Constituency Council may make bylaws, and you have a whole list. And it says, and in particular clause A, for the circumstances in which a license may or shall be granted, refused, revoked, or suspended. It would have been a very helpful thing if in the body of the legislation that at least some indication was given of the precise activities that require licensing. Again, because of the peculiarities of licensing arrangements. Mr. Speaker, as I said earlier on, I think this bill is very deeply flawed. I really wish that this bill had the benefit of some consultation with the parliamentary representatives in the area. I don't think that they would have been hostile to some of the proposals contained therein. I don't think so. I think they themselves would have wanted to contribute and deal with some of the provisions. And I really regret, Mr. Speaker, that the partnership that was established in the original Constituency Council Act was ignored on this occasion. Mr. Speaker, I'm now accustomed in this House when suggestions are made to be disregarded and frowned upon. A few from time to time, when they're inescapable, are accepted. It's really not too late to go back to the drawing board with this, and neither am I asking. I certainly am not asking to go back to the drawing board, but I do believe that those persons who have constituencies to be represented by the Constituency Council need to reflect very carefully. Finally, Mr. Speaker, let me say this. All of us in this House have had the opportunity to watch the stewardship of the current mayor. Some of us have met him in other fora, or some of us have had to deal with his actions in other fora. All I'm saying is this.